They served me with a civil lawsuit on a Thursday morning. Not a complaint letter, not a fine notice. An actual civil lawsuit filed in Garfield County District Court claiming negligence, premises liability, and willful disregard for community safety, seeking $47,000 in damages plus legal fees. The plaintiff was Miriam Foss, 64 years old, board president of Stonegate HOA. Owner of a cream-colored Audi Q7, she parked in the exact same spot every morning at 7:53 regardless of weather. And the woman who had been standing outside my driveway on the morning of January 9th, doing what I would later demonstrate in court she had been doing every Tuesday and Thursday morning for 6 weeks. The incident she was suing me over had occurred on January 9th at 8:04 in the morning. She had slipped on ice. She had fallen. She had sustained a bruised tailbone and what her medical records described as mild soft tissue injury to her left wrist. She had missed 4 days of work at the property management company she owned and operated, which was the same company that the Stonegate HOA had retained to manage its administrative affairs, which meant she was essentially employed by herself, and the 4 days of missed work were 4 days she had not paid herself from a company whose expenses the HOA funded. That part would become relevant later. My name is Cleo Marsh. I am 41 years old. I am a forensic video analyst. I have spent 17 years examining digital footage for insurance companies, law firms, and municipal agencies, identifying what footage actually shows as opposed to what people claim it shows, establishing timelines, authenticating recordings, and occasionally demonstrating in court proceedings that the version of events presented by one party is inconsistent with what the objective record captures. When Miriam Foss filed a lawsuit against me over ice on my property, she made a specific calculation. She calculated that I was a homeowner with a normal job and normal resources, and a normal human reluctance to spend money on legal proceedings when a settlement might make the problem go away. She did not know what I did for a living. She did not know that I had 8 exterior cameras on my property with overlapping fields of view, motion-activated recording at 4K resolution, and 18 days of retained footage at the time she fell. She did not know that I had reviewed that footage the morning of the incident, before her attorney's letter arrived, and had made a copy of everything to a secure backup. She did not know that I had been watching what she did in front of my property every Tuesday and Thursday morning since the previous November, and that I had documentation going back 6 weeks. Comment below where you are watching from. Because this story ends with a lawsuit dismissed with prejudice, a counterclaim that produced a settlement Miriam Foss paid from her personal account, and 17 minutes of footage played in a courtroom that changed every assumption the opposing attorney had made about what the case contained. Part 1109. Stonegate is a 78-home development in western Colorado, built between 2004 and 2011, on terrain that is beautiful in the way that western Colorado terrain is beautiful, which is to say completely, and without any concession to the logistical complications that beauty at altitude creates. We are at 6,800 feet. We get an average of 112 inches of snow annually. We get freeze-thaw cycles in January and February that can produce ice on surfaces that were clear 8 hours earlier regardless of how diligent you are about clearing them. I bought my house in Stonegate in 2017 after my divorce, specifically because the corner lot had 2 detached garages and I needed the space for equipment storage. The cameras were installed in 2018 after a car sideswiped my fence at 2 in the morning, and the driver did not leave information. I wanted documentation. 8 cameras covering the front yard, both side yards, the driveway, the garage access, and the street-facing portion of the property from 2 angles. The system retained 30 days of footage to a network-attached storage device in my home office and simultaneously backed up to a cloud service I had been using for 6 years. The cameras were not secret. They were visible. 2 of them had small indicator lights that were on whenever they were recording, which was always. I had mentioned the system at a Stonegate board meeting in 2019 when Miriam, who had just taken the board president position, had proposed a community surveillance policy. I had said I already had my own system and that it was functioning. She had noted it and moved on. I had not thought about that conversation again until January. Miriam Foss had become board president in 2019 by running on a platform she called Stonegate Forward, which involved a set of community standards initiatives that looked comprehensive in the document she distributed and functioned in practice as a mechanism for Miriam to have enforceable authority over aesthetic decisions she felt strongly about. The authority part she used frequently. In my first year under her presidency, I received 4 violation notices. A vehicle parked outside my garage for 40 minutes during an equipment unloading operation. A trash bin visible from the street on a pickup morning before I had moved it back. A holiday decoration that exceeded the board's approved size specification by 4 inches. And a crack in my driveway apron that the violation notice described as a safety hazard requiring remediation within 30 days. The crack was 2 inches wide and had been there since before I bought the house. I addressed 3 of the 4 violations without significant dispute. The vehicle one I contested formally because the vehicle had been on my property for 40 minutes during active use, which was explicitly permitted under the HOA's own governing documents. Miriam rescinded it after my written response cited the specific section, but she noted the response in the board minutes as requiring monitoring for future compliance. I know this because I requested and received the board minutes for that period. Monitoring for future compliance was not standard language in Stonegate HOA board minutes. It was language Miriam had added when she wanted a record that a particular homeowner had been identified as a concern. I had 4 such notations in 2 years. My neighbor 2 houses down had 3. A woman at the end of the block had 6. All of us had contested violations at some point. All of us had been added to what I privately called the monitoring list. None of us had been told the list existed. I discovered it by reading meeting minutes carefully, which I had started doing after the 4th violation notice because I recognized that Miriam was systematic and that systematic people leave records of their systems if you know where to look. The property management company Miriam owned was called Summit Ridge Property Services. It had been retained by the Stonegate HOA in 2019, 2 months after Miriam became board president. The contract paid Summit Ridge $3,800 monthly for administrative management services. I had noted this in the financial statements I reviewed annually and had asked at a board meeting whether the contract had gone through competitive bidding. Miriam said it had. I asked to see the bid documentation. She said it was in the executive session files. I sent a formal records request citing Colorado HOA statute. The response came 3 weeks later and contained a single competitive bid document in addition to Summit Ridge's proposal. The competing bid was from a company called Clearwater Management Solutions. The bid was for $3,200 monthly, $600 less than Summit Ridge. Summit Ridge had been awarded the contract anyway. I had looked up Clearwater Management Solutions in the Colorado Secretary of State Business Registry. It did not exist. The registration number on the bid document was not in the registry. The competing bid that had justified awarding the contract to Miriam's own company had been submitted by a company that did not exist. I had put that in a folder in November of the previous year and had been deciding what to do with it when January happened. The ice on January 9th was real. I want to be clear about that. There was ice on the public sidewalk that ran along the front of my property. I had treated my driveway and the private walkway to my front door with ice melt the previous evening, when the forecast showed overnight temperatures dropping to conditions that would refreeze the snowmelt from the previous day's warming. I had not treated the public sidewalk because, in Garfield County, the public sidewalk adjacent to residential property is maintained by the municipality. The county's snow and ice removal ordinance placed responsibility for sidewalk clearing on the adjacent homeowner for snow, but specified that ice formation resulting from normal freeze-thaw cycles was a municipal maintenance responsibility, unless the homeowner had actively created the condition through drainage or runoff. I knew this ordinance because I had read it 2 winters earlier, when a different sidewalk situation had made me want to understand the liability framework. I had not actively created any drainage condition. The ice was ambient. It was everywhere on that block, not uniquely present on my sidewalk, not uniquely thick, not uniquely hazardous. It was the ice that January in western Colorado produces when the temperature does what it does regardless of what homeowners do. Miriam slipped at 8:04 in the morning. She was walking on the public sidewalk adjacent to my property. She fell. She was helped by a passing neighbor. She called her doctor, who saw her that afternoon and documented the bruised tailbone and wrist soft tissue injury. She called her attorney that evening. Her attorney sent a demand letter the following Monday seeking $12,000 in a pre-litigation settlement. I did not call my own attorney immediately. I went to my home office and reviewed the footage from the morning of January 9th. Part 2, 2440. The footage from camera 3, which covered the front of my property including the public sidewalk from a northwest angle, showed the following sequence on the morning of January 9th. At 7:51, Miriam Foss's Audi Q7 parked at the curb in front of my property. She always parked there on Tuesday and Thursday mornings. At 7:53 she exited the vehicle. She stood at the curb for approximately 4 seconds. She looked down. She looked at the sidewalk surface. She took 2 steps onto the sidewalk and stopped. She looked down again. She opened her car door and removed an object from the center console. The object was small, rectangular, and dark-colored. She held it in her right hand. She closed the car door. She walked 11 steps north along the sidewalk, turned to face my property, and stood for approximately 8 seconds with the object in her hand. She then took 4 steps back south, placed her right foot forward, paused for 2 seconds, and fell. Camera 4, which covered the same area from a southeast angle, showed the same sequence from a different perspective and confirmed the object in her hand was a phone with its camera application active. The camera 4 angle also showed something camera 3 had not fully captured. When Miriam placed her right foot forward in the 2 seconds before she fell, her left foot was not on the icy sidewalk surface. It was on the cleared strip of my private driveway apron, which was treated with ice melt and dry. She had moved herself from the dry, treated surface to the icy public sidewalk in the moment before the fall. I watched the full 17 minutes of footage covering the period from her arrival through the arrival of the neighbor who helped her. I watched it 3 times. Then I made a copy to 2 separate external drives, uploaded a second copy to a separate cloud account I used only for evidence preservation, and made a third copy on optical disc. Then I called an attorney. My attorney was a woman named Petra Vallow who practiced civil litigation in Garfield County and had a specific professional interest in premises liability cases. She had a reputation for thorough preparation and a low tolerance for claims she considered unmerit-worthy. She watched the footage in my home office on a Friday afternoon. She watched it twice. Then she looked at me over her reading glasses. "Cleo," she said, "she's staging it, I know." She looked at the footage again. "The phone," she said, "the camera app. She was going to photograph her fall or video it. She fell before she could, I know. How long have you had this system?" "Since 2018. She was quiet for a moment. "We are going to respond to the demand letter with a counter-demand," she said. "And when she files, because she is going to file, we are going to be ready." I told her about the Clearwater Management Solutions bid document. She read the folder I had prepared. She looked at the Colorado Secretary of State Registry printout showing no record of Clearwater Management Solutions. She read the Summit Ridge contract amount and the competing bid amount. She said, "How long have you had this?" "Since November." She said, "And you were waiting." I said I was waiting until I understood the full picture before deciding what to do with it. She said, "The lawsuit is going to change what you do with it." "Timing," I said. She understood immediately. "If we produce this in discovery, it changes the case from a premises liability dispute to something considerably more complex for Miriam Foss." "Yes, and she will not know we have it until we produce it. She did not know what I did for a living. Petra's eyes moved to my home office equipment, 4 monitors, analysis software, evidence storage systems, the setup of someone who worked with footage professionally. She did not know, Petra said. No. She filed a complaint against a forensic video analyst. Petra looked at the footage one more time. She said, "How many other cameras did you say?" 8, all with overlapping fields of view. She nodded. Let her file. Miriam filed in December after my counterdemand was rejected. The complaint alleged negligence, premises liability, and willful disregard for community safety. It sought $47,000 covering medical expenses, lost wages from Summit Ridge Property Services during her 4-day recovery, pain and suffering, and legal fees. The lost wages line was interesting because it required Summit Ridge's invoicing to the HOA to be disclosed as supporting documentation, which meant that in the course of pursuing a premises liability claim, Miriam was going to have to produce financial records for the company whose contract with the HOA she had approved with a fabricated competing bid. Petra filed our initial response and simultaneously served a discovery request. The discovery request was specific, comprehensive, and built around what we already had. We requested all footage or photographs taken by Miriam Foss or at her direction on January 9th on the public sidewalk adjacent to my property. We requested her phone records for the 30 minutes surrounding the incident. We requested her phone's camera application usage history for the morning of January 9th. We requested all Summit Ridge Property Services financial records for the period of the HOA contract. We requested all documentation supporting the competitive bid process that had awarded the Summit Ridge contract. We requested all communications between Miriam Foss in her capacity as HOA Board President and Miriam Foss in her capacity as Summit Ridge Property Services Principal for the duration of the contract. And we requested all board meeting minutes containing the phrase monitoring for future compliance. Miriam's attorney, a man named Darren Stacy, who had been practicing civil litigation for 22 years, and who I later learned had not been told by Miriam what the full factual situation was before he filed the complaint, called Petra 3 days after the discovery request arrived. His tone, by Petra's description, was that of someone who had just received information that required a reassessment of his understanding of the case. He asked for a 2-week extension on the discovery response deadline. Petra granted it. She told me afterward that the extension request from an experienced litigator 3 days after receiving discovery meant one of 2 things. Either he had an unusually full docket or he had read our discovery request and had gone back to his client with questions she had not been prepared to answer. 2 weeks later, the discovery response arrived. It was incomplete in the specific way that discovery responses are when the producing party has decided which items to fight. The phone records were not included. The camera application usage history was not included. The Summit Ridge financial records were partially produced, covering only the period after the HOA contract, not the period of Miriam's application for the contract. The Clearwater Management Solutions documentation was not produced. The board meeting minutes containing the monitoring language were not produced. Petra filed a motion to compel. The motion cited each missing item, the specific discovery request it responded to, and the applicable Colorado rules of civil procedure requiring production. She attached our footage from Camera 3 and Camera 4 as exhibits to the motion, noting that the footage showed Miriam holding an object consistent with a phone with camera application active on the morning of the incident, and that the requested phone records and camera usage history were directly relevant to what the footage showed. Darren Stacy called Petra the morning the motion was filed. He asked for a settlement conference. Petra said a settlement conference was available after full discovery compliance. He said his client was willing to settle the case for a reduced amount. Petra said our client was not interested in paying any amount for a claim she considered without merit, and that if Mr. Stacy wanted to discuss resolution, He should review the footage we had attached to the motion to compel and call back after that conversation with his client. He called back in 2 hours. Part 3, 4235. What Darren Stacy had seen in the footage and what he had then discussed with Miriam Foss produced, by his own subsequent account in the Bar Association proceeding that followed unrelated to our case, a conversation he described as clarifying. He had asked her directly whether she had been holding her phone on the morning of the incident. She had told him she had not. He had watched the footage. He had called her back and asked again. Her second answer was that she might have had her phone out but that it was irrelevant to the premises liability claim. He had explained that it was not irrelevant because if she had been attempting to document her fall for purposes of a claim, that changed the legal character of the incident from an accident to a staged event, which changed his professional obligations substantially. The settlement conference was scheduled for a Thursday morning in Petra's office. I attended. Darren Stacy attended alone. Miriam Foss did not attend, which is not unusual in settlement conferences, but which in this case carried the specific texture of someone who had been advised by her attorney that her presence would not be an asset to the discussion. Darren opened by acknowledging that the footage raised questions about the circumstances of the incident. He proposed dismissal of the complaint without prejudice in exchange for our agreement not to pursue a counterclaim. Petra said we were not interested in that structure. Dismissal without prejudice meant Miriam could refile. We wanted dismissal with prejudice, and a resolution of the counterclaim we intended to file covering our legal fees and the matter of the fabricated competing bid. Darren said his client disputed the characterization of the bid documentation as fabricated. Petra put the Colorado Secretary of State Registry printout on the table. The one showing no record of Clearwater Management Solutions at the registration number appearing on the bid document Miriam had produced to support the Summit Ridge contract award. The registration number on the bid document, Petra said, is not in the state business registry. Clearwater Management Solutions does not exist. The bid was fabricated to create the appearance of competitive process for a contract your client awarded to her own company using HOA funds. Darren looked at the printout for a long time. Then he said he needed to speak with his client before responding to that portion of the discussion. The conference recessed for 45 minutes. When Darren returned, his posture had changed in the specific way that attorneys' postures change when they have received information from their clients that has not improved the situation. He proposed dismissal with prejudice of the premises liability claim and a resolution of the fabricated bid matter through repayment of the Summit Ridge contract excess over the lower valid bid amount. The Summit Ridge contract had paid $3,800 monthly. The Clearwater bid, fabricated though it was, established that a legitimate competing bid had been at $3,200, $600 monthly differential. The Summit Ridge contract had run for 31 months, $18,600 in excess payments beyond what the competing bid would have cost. Petra said $18,600 was the floor, not the resolution. The full Summit Ridge contract represented a self-dealing transaction that had not been properly disclosed, that had been supported by a fabricated competitive bid, and that created personal liability for Miriam Foss under Colorado HOA statute, requiring board member disclosure of financial interests in vendor relationships. The full amount was $117,800, the complete Summit Ridge contract value over 31 months. Plus our legal fees in the current matter, which at that point were $14,200, plus the cost of a forensic audit of all HOA financial records during Miriam's presidency, which we were requesting as part of the resolution. Darren said that figure exceeded his client's ability to pay from personal funds. Petra said that was his client's problem and not our constraint, but that we were willing to discuss a payment structure that allowed resolution without litigation in Garfield County District Court in a proceeding that would be public record. The mention of public record produced another recess. This one was 20 minutes. When Darren returned, he had a number: $72,000, Full dismissal with prejudice of the premises liability claim. Personal payment from Miriam Foss to the Stonegate HOA of $60,000 representing partial restitution of the Summit Ridge excess payments. Personal payment from Miriam Foss to our legal defense fund of $12,000 covering fees. And resignation from the Stonegate HOA board effective immediately, with a commitment not to seek board positions within Stonegate or serve as an HOA management contractor for any Stonegate-related entity for 5 years. We accepted the structure with one addition. The HOA board was to be notified in writing of the reason for her resignation, not a vague personal reasons letter, a specific written acknowledgement to the full board that she was resigning in connection with a resolution of a financial matter involving the Summit Ridge contract and a premises liability lawsuit. The written acknowledgement was the part that mattered to me beyond the money. Miriam had been managing what other people knew about her conduct for 3 years, the monitoring list, the fabricated bid, the lawsuit she had filed expecting a settlement and received instead a 17-minute video. She had operated on the assumption that she controlled the information environment. The written acknowledgement to the board was the end of that control. Darren said his client would accept that structure. The settlement agreement was executed the following Monday. Miriam resigned from the board that afternoon. Her letter to the board, which I saw because Petra required a copy, contained the specific language that had been negotiated. It stated that she was resigning in connection with the resolution of legal matters, including a premises liability claim she had filed and a separate matter involving the Summit Ridge Property Services contract, and that the full details were available from the HOA's legal counsel. The board received the letter at their monthly meeting and spent, based on what the subsequent meeting minutes showed, approximately 90 minutes discussing it. The questions they asked at that meeting were the right questions. They hired an independent attorney to review the Summit Ridge contract documentation. They commissioned a forensic accountant to audit 3 years of HOA finances. They suspended the Summit Ridge contract pending the audit. The audit took 8 weeks. What it found beyond the fabricated bid and the contract excess was 2 additional vendor relationships that bore the same structure as Summit Ridge. A landscaping vendor whose contract had been awarded without competitive process and whose ownership, identified through the registry search the auditor ran as a matter of course, included a family member of one of Miriam's board allies. An insurance broker relationship that had been renewed annually for 3 years at rates the auditor found to be 11% above comparable market rates, with the broker having a referral relationship with Summit Ridge Property Services that had not been disclosed. Total financial irregularities identified across the full audit, $141,000 including the Summit Ridge excess, the landscaping vendor overcharges, and the insurance premium differential. The HOA's attorney filed a civil complaint against Miriam Foss for the full amount, separate from the settlement that had already resolved our personal claim. Miriam hired new counsel. The case settled 18 months later for $83,000, which was the extent of what was recoverable from her personal assets after the previous settlement had been paid. The remaining $58,000 became a judgment debt. The Stonegate HOA held new elections. 3 new board members were seated. The first governance actions were the ones that boards take when they understand why governance failures happen and intend to prevent recurrence. Monthly financial statements distributed to all homeowners with line item detail. All vendor contracts above $1,000 monthly requiring competitive bids with documentation retained. Board member conflict of interest certifications filed annually. A community member oversight committee with access to financial records and authority to request independent review. The Summit Ridge contract was not renewed. The HOA retained a management company through a competitive process that produced 4 legitimate bids. The lowest was $2,600 monthly. They awarded it to the second lowest bid at $2,900 because the references were better. The monitoring for future compliance language never appeared in board minutes again. The lawsuit was dismissed with prejudice on a Thursday. Petra called me when the signed dismissal order was filed by the court. I was at my desk reviewing footage for a different case, an insurance claim involving a slip and fall at a retail location where the store's own camera system had captured something the claimant's attorney had not reviewed before filing. She said, "It is done." I said, "Good." She said, "Cleo, in 22 years of civil litigation, the motion to compel I filed in your case is the only one I have filed that attached surveillance footage of the plaintiff staging the incident." I said, "It was not staged well." She said, "No, it was not." She paused. "You knew before she filed." "I knew the morning she fell," I said. "You let her file anyway." "I let her make her choices," I said. "She had been making choices for 3 years. I had documentation going back 6 weeks on what she did in front of my property on Tuesday and Thursday mornings. I wanted her choices to be on the record." Petra was quiet for a moment. "The monitoring list," she said. "The fabricated bid. The Summit Ridge contract. You were going to find a way to surface all of that regardless of the lawsuit." Yes, the lawsuit was her choice. It gave me a vehicle I would not have had to surface it as completely. She said, "In future, if someone asks me whether it is strategically sound to sue a forensic video analyst over a fall on a public sidewalk that her own cameras covered, I'm going to tell them about this case." I said, "That seems useful." She said it did. I went back to my other case. The footage was clear. The facts were in the record, everything documented, everything preserved, everything exactly where it needed to be when someone needed to see what had actually happened. Framed thumbnail text. "Sued me over ice on MY sidewalk." Subtext. "One video destroyed her case."